Ingalls Markets is hiring in all divisions: retail, distribution, corporate, and pharmacy. Ingalls is an equal opportunity employer offering competitive wages, advancement opportunities, benefits, and holiday vacation sick pay. For more information and to apply, visit ingalls-markets.com/careers.
Please remember that this is meant to be a snapshot of topics that affect entrepreneurs, but you should always consult an attorney to customize this type of protection to your specific grind.
Welcome to another episode of
Entrepreneur Bind and Grind.
My name is Reba J.
And I am Christine Rhodes.
And we are here to spread knowledge that can protect the legal and business interests of the
modern entrepreneur who's on their grind.
If this is your first time listening to us, welcome.
And if you're one of the OG B&G crew, welcome back.
Welcome back. Today we'll be focusing on trademarks, so grab a cup of tea.
Or a shot of whiskey.
And let's get to it.
But remember, we are friends in your head, not your attorney. All right, so all the way back in season 1, we dropped a tiny bit of knowledge about trademarks, and as promised, have come back to give you more.
If you have not listened to that episode, stop, go back, and then listen to this one. You can also enjoy it on our new YouTube page.
Yay!
Yes, y'all, we have a YouTube. Look up Entrepreneur Bind and Grind.
Okay, so quick recap from the previous episode. The United States Patent and Trademark Office defines a trademark as a word, phrase, symbol, or design, or a combination thereof that identifies and distinguishes the source of the goods of one party from those of others.
A service mark is the same as a trademark, except that it identifies and distinguishes the source of a service rather than goods.
A trademark typically protects brand names and logos used on goods and services. A trademark is all about the words and symbols you use to recognize businesses.
You can get protection for a trademark for as long as you use it openly and defend it against others.
All right, so key information about trademarks. What can you trademark? You can trademark colors, sounds, visuals, logos, fabrics, smells, and a variety of other things as long as it is used to distinguish your products and is not linked to the functionality of the product or the service.
So basically, you cannot trademark a generic name like toilet paper to prevent other people from describing their own product. You cannot trademark a descriptive word or one that is misleadingly descriptive, like table maker for a carpentry business won't fly, and neither will the name Chinese porcelain maker when the products are made in the U.S.
Right. Trademarks distinguish your brand apart from others. It protects the very thing that makes it different from your competitor, not the actual product or service. That being said, it is very possible to infringe on the trademarks of others while creating your brand.
So top tip, do some initial research when you start fleshing out your idea. You can prevent a lot of frustration by not focusing on this wild new idea that is already trademarked and run by someone else across the country or in the next town over.
So people will tell you all day that you don't need to record your trademark with the federal government because you get the protection automatically. That is true and false at the same time.
You definitely get some protection, but you don't get all of it. When your mark is unregistered, you can't bring a claim to court and get the same amount of damages.
Your registration is prima facie evidence that you are the owner of that mark. Prima facie basically means that it is like the thing that you need. Like it is almost the smoking gun of evidence to say like, oh, this is me. You are telling the left hand that the right hand already gave you permission. Listen, your homeboys in this other branch of government already gave me the key and said that this is mine. So here you go, Mrs. Judge, give me my money. And the judge will say, granted. Case dismissed. Run her check.
There you go.
All right. So with that, you also get national coverage with your trademark registration. Customs can stop counterfeit goods from coming into the country.
You'll also get attorney fees when you win the case, additional damages when you win the case, and obtaining injunctions from the courts to prevent others from using your mark.
All right. So courts look at whether the trademark infringement is confusingly similar to the original trademark that a regular, ordinary buyer would believe the products come from the same source without having to look for subtle differences. Like, oh, my bottle is 6 inches tall and the original is 7 inches, so we're different, so I'm not infringing.
Right. Okay. Courts will also consider if there's a likelihood of confusion, that the two marks are so close together that it's likely to create consumer confusion as to the origin of the product. There are several main factors that the courts consider. All of them are not dispositive, and this isn't the final list. Each situation is carefully weighted by the court, and therefore there's no clear line.
All right, so scenario number 1 is strength of the senior user's mark. All right, we all know that Nike is super strong. That is a strong trademark. They're going to take that into consideration. The marketing channels used. Are you marketing on the same platforms as the senior mark user? The similarity of the conflicting marks. Is yours a swoosh instead of a swoop? Like, judge is gonna be like, nah, fam, that's not how it goes.
Just like that, he gonna say, nah, fam.
Right. And then the degree of care likely to be used by purchasers in selecting the goods. So is it something that somebody's just gonna randomly, casually look over and pick up, or is it something that they're have to have a more intelligent buying process about it? Like, is it art, or is it, some like sneakers or different things where they'll be like, oh, okay, well, if there's a higher level of detail, you might be able to slide on it, but very, very, very unlikely.
Right. And then the second comer's intent to selecting this mark. So why did the second person decide that this was the mark they wanted to use? Also, evidence of actual confusion. So, like, have there been times where people have been confused? They bought this one product and they thought it was this other product, and then, all that goodness. Likelihood of expansion in the product line. So, were they planning to expand into other areas? Like, are you now infringing on their ability to do so? Relatedness or proximity to the two companies. How close are you to them? Like, is this a mom and pop shop in one town and you're also there trying to, like, take their customers from them? Like, I mean, that's real. So these are some of the things that they look at, and they'll weigh this to see which way they're gonna basically.
Right. And, in one situation, they're like, oh, that doesn't matter. And the other one, that's the thing that solidifies your case and allows you to, again, get that check.
Yep.
All right. So, but underneath the Trademark Dilution Act of 1995, which became law in 1996, the owner of a famous trademark can now stop someone from using its trademark if it tends to weaken, blur, or tarnish the famous mark. So the court doesn't even need to go through the factors of the likelihood of confusion test. We all knew Mr. McDowell was ripping off McDonald's.
Come on. Yeah.
Like, arches and arcs, sir. No.
Yeah. Just like Kim Kardashian. You can't come out here and name yourself Kim Kardashian. I know she got that thing trademarked. So let's keep it 100 and then be out here doing some crazy stuff.
Or kimono, because she could not do that.
Listen, It happens. So this is a wrap for the trademark episode. Again, just know that these are the beginning stages of trademark law. It can get crazy and complicated because you are dealing with the U.S. government.
Right. So you can easily get caught up in the intricacies of the law and find yourself with a denied application. So, what do we say? Get an attorney.
Yes. Please get a local attorney who's actually specialized in this area or has experience in this area, something of that sort. But what we're also going to do is next week's episode, we're going to bring in a special guest, of somebody who has experience with trademarks, who give you some tips and tricks of, what to look for. And the thing is, yes, we're telling you to go get an attorney, but it's good to have some background knowledge yourself. So when you're going to talk to these attorneys and you're interviewing these attorneys, you can see if they really know what they're talking about, right? Because again, you should be interviewing attorneys. Don't just go to the first one you find on Google.
Right.
Thank you.
Although, they may be dope because everybody gives them testimonials, or they just may be dope at SEO.
Yes, they might be paying for the SEO.
Listen, we love and appreciate each and every one of our B&G crew for tuning into another episode of
Entrepreneur Bind and Grind.
To get more info on ways that you can protect your trademarks.
Remember, we are friends in your head, not your attorney.
Check out our website at 28media.com.
And follow us on Instagram and Facebook at 28media. Number 2, spelled out 8, add media.
You can also find us on YouTube at Entrepreneur Bind and Grind.
Don't forget to subscribe, share, rate, and like this episode if we've just taken your grind to the next level.
Until next time, keep grinding.